Hello viewers, in our previous lesson we studied about the international commercial arbitration. Today we would be dealing with the topic of recognition and enforcement of foreign award. The objectives of this lesson are to understand the procedure for enforcement of foreign arbitral award under the New York Convention and the Geneva Convention, to understand the appropriate court for the enforcement of foreign award, to study about the difference when the seat of arbitration is in India and the seat of arbitration is outside India. The recognition and enforcement of foreign awards is of vital importance for the success of international commercial arbitration. The recognition and enforcement provide official recognition to the arbitration process and confirm the award. Further, if any party does not comply with the award voluntarily, the recognition and enforcement of the award provides the help of the state courts for the compulsory enforcement of the award. The harmonization of the laws relating to international commercial arbitration with the help of UNCITRAL Model Law on International Commercial Arbitration 1985 and international instruments for the recognition and enforcement of foreign arbitral awards like Geneva Protocol on Arbitration Clauses 1923, Geneva Convention on the Execution of Foreign Arbitral Awards 1927 and New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958 have provided the legal framework for the success of international commercial arbitration. In India, the Part 1 of the Arbitration and Conciliation Act 1996 provides for the enforcement of the award in international commercial arbitration with seat in India, and the Part 2 of the Act provides for the recognition and enforcement of foreign awards, that is, arbitration award passed outside India in a reciprocating country to the New York or Geneva Convention. Let us study about the international commercial arbitration with seat in India. If the seat of international commercial arbitration is in India, it would be governed by the same rules and regulations as domestic arbitration, because it is governed by the Part 1 of the Arbitration and Conciliation Act 1996. We have already discussed in detail about the law regulating the arbitration in India in our previous lessons. Now, we will study in brief only the provisions specifically relating to international commercial arbitration in the Part 1 of the Act. Appropriate court. The Amendment Act of 2015 has introduced a separate definition of court for international commercial arbitration by way of Section 2, Subclause 1, Subclause E 2. According to it, in case of international commercial arbitration with seat in India, only the High Court in exercise of its original civil jurisdiction or High Court having appellate jurisdiction with respect to the subject matter of arbitration would be the relevant court. This provides convenience to foreign parties as they do not need to litigate in remote areas of the country. Appointment of arbitrator by court and determination of fees. According to Section 11 of the Act, if a party fails to appoint an arbitrator within 30 days from the receipt of the request from the other party, or if the two appointed arbitrators fail to agree on third arbitrator within 30 days of their appointment, then upon the request of a party, the appointment of the arbitrator shall be made by the Supreme Court in case of an international commercial arbitration. This power of appointment can also be delegated by the Supreme Court to any person or an institution. Further, the court is not empowered to frame rules regarding the fees of the tribunal, and the parties and the tribunal may fix the fees as per their agreement. law applicable to the substance of dispute. In case of international commercial arbitration, as per section 28 subclause 1 subclause b, the arbitral tribunal shall decide the dispute in accordance with rules of law designed by the parties or according to the law of a given country as designated by the parties, and if the parties do not choose any law, the arbitral tribunal shall apply the appropriate rules of law according to the circumstances surrounding the dispute. Set aside of arbitral award. Section 34 of the Act provides for the manner and grounds for the challenge of arbitral award. The application for set aside may be filed within 3 months from the date of receipt of the arbitral award, which can be extended for a further period of 30 days by the court on sufficient cause being shown for condonation of delay. All the grounds for set aside of award in domestic arbitration are also applicable to international commercial arbitration with seat in India, as the award is a domestic award. However, as per section 34 subclause 2a of the Act, the ground of patent illegality is not available to set aside the award in international commercial arbitration. Now, we will examine the provisions relating to international commercial arbitration with seat outside India. The part 2 of the Act deals with recognition and enforcement of foreign awards. The chapter 1 of part 2 of the Act deals with the New York Convention awards, whereas chapter 2 of part 2 of the Act deals with Geneva Convention awards. Foreign award under the New York Convention. Sections 44 to 52 of the Arbitration and Conciliation Act 1996 deal with foreign award passed under the New York Convention. According to section 44, foreign award under New York Convention means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, made on or after the 11th day of October 1960, in pursuance of an agreement in writing for arbitration to which the New York Convention applies, and in one of such territories as the central government being satisfied that reciprocal provisions have been made, may by notification in the official gazette declare to be territories to which the New York Convention applies. Therefore, the prerequisites for enforcement of foreign awards under New York Convention are: firstly, the award must arise out of an arbitration agreement dealing with differences between persons arising out of legal relationships, whether contractual or not. Secondly, the relationship must be considered as commercial under the Indian law. Thirdly, the arbitration agreement must be in writing. Fourthly, the award shall be made in one of the reciprocating countries of New York Convention, declared by central government by notification in official gazette. About 48 countries have been notified by the Indian government so far. They include Australia, Hong Kong, Japan, Singapore, United Kingdom, United States of America, etc. Reference to arbitration. According to section 45 of the Act, a judicial authority has the power to refer those parties to arbitration who have entered in an arbitration agreement as per the section 44 of the Act. It is mandatory for the judicial authority to refer the parties to the arbitration, but the court has to be satisfied that the agreement is valid, operative and capable of being performed. The foreign award must be valid and arise from an enforceable commercial agreement. In the case of Kharda Company versus Raymond and Company, AIR 1962 SC 1810, the Supreme Court held that an arbitration clause cannot be enforceable when the agreement of which it forms an integral part is declared illegal. The Supreme Court in World Sport Group Mauritius Limited versus MSM Satellite Singapore Limited AIR 2014 SC 968 has opined that no formal application is necessary to request a court to refer the matter to arbitration under section 45 of the Act. In case a party so requests, even through affidavit, a court is obliged to refer the matter to arbitration, with the only exception being cases where the arbitration agreement is null and void, inoperative and incapable of being performed. Therefore, the scope of judicial scrutiny at the stage of referring a dispute to foreign seated arbitrations is very limited. Application for enforcement. Section 47 of the Act provides that at the time of making an application for enforcement of foreign award, the applicant party shall produce before the court firstly original award or its duly authenticated copy, secondly original arbitration agreement or its duly certified copy, and thirdly any evidence required to establish that the award is a foreign award. After the Amendment Act of 2015, the explanation to section 47 has provided that the application for enforcement of a foreign award lies only to the High Court. Grounds for refusal of enforcement. It is an obligation of the court to recognize and enforce the foreign awards only with limited exceptions. Once an application for enforcement of a foreign award is made, the other party has the opportunity to file an objection against enforcement on any of the grounds recognized under section 48 of the Act. The enforcement of a foreign award may be refused by the court only if the party against whom the enforcement is sought can show existence of any of these grounds. The parties to the arbitration were under some incapacity under the law applicable to them, or the arbitration agreement is not valid under the agreed law or under the law of the country where the award was made. The party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or of the arbitral proceedings, or was unable to present his case. The award deals with a difference not contemplated by or not falling within the terms of submission to arbitration, or it contains a decision on matters beyond the scope of submission to arbitration. However, if the decisions on matters submitted to arbitration can be separated from those not submitted to arbitration, then the part of the award which contains decision on matters submitted to arbitration may be enforced. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or not in accordance with the law of the country where the arbitration took place. The award has not yet become binding on the parties, or the award has been set aside or suspended by a competent authority of the country in which or under the law of which the award was made. Further, if an application for setting aside or suspension of the award has been made to a competent authority and the same is pending, the court may adjourn the decision on the enforcement of the award. However, on the application of the party claiming enforcement, the court may order the other party to give suitable security. The subject matter of the difference is not capable of settlement by arbitration under the law of India. The enforcement of the award would be contrary to the public policy of India. The Amendment Act of 2015 has added two explanations to section 48 subclause 2. These amendments primarily seek to clarify the meaning of public policy under section 48 and the scope of review of the court. The explanation 1 clarifies that an award is in conflict with the public policy of India only if it was induced or affected by fraud or corruption or in violation of section 75 or section 81 of the Act, which deal with confidentiality and admissibility of evidence of conciliation proceedings in other proceedings, or it is in contravention with the fundamental policy of Indian law, or it is in conflict with the most basic notions of morality and justice. Further, explanation 2 stipulates that the court shall not review the award on merits to determine whether the award is in contravention with the fundamental policy of India. It is also pertinent to note the ground that the award is patently illegal is not available for the refusal of enforcement of the foreign award. Prior to the amendment, there was a lot of confusion regarding the scope of the term public policy. In Renusagar Power Company Limited versus General Electric Company 1994 Supplement 1 SEC 644, the Supreme Court on narrow approach to public policy observed that it must be interpreted in the sense the doctrine of public policy is applied in the field of private international law. The court held that a foreign award would be refused on the ground that it is contrary to public policy if such enforcement would be contrary to fundamental policy of Indian law or the interests of India or justice or morality. But this approach to public policy was overruled by the Supreme Court in ONGC versus Saw Pipes Limited 2003 5 SEC 705. In this case, the court had held that public policy of India is required to be given wider meaning and added that the award could be set aside if it is patently illegal. Further, in Phulchand Exports Limited versus Patriot 2011 10 SEC 300, the Supreme Court again confirmed that if the award is patently illegal, it would be against public policy of India as used in section 48 subclause 2 subclause B. However, in Sri Lal Mahal Limited versus Profetto Grano 2014 2 SEC 433, the Supreme Court reversed the position on patent illegality and concluded that the public policy of India must be given a narrow meaning and the enforcement of a foreign award would be refused on the ground that it is contrary to public policy of India if it is covered by one of the three categories mentioned in Renusagar case. Now, the Amendment Act of 2015 has excluded the patent illegality and brought clarity to the term of public policy. Enforcement and appeal. Section 49 of the Act provides that where the court is satisfied that the foreign award is valid and enforceable under this chapter, the award shall be deemed to be a decree of the court and shall be entitled to be executed as a decree of the court. Under section 50 of the Act, an appeal can be filed by a party against those orders passed under section 45 and section 48 of the Act. However, no second appeal can be filed against the order passed under this section. The Supreme Court in Jindal Exports Limited versus Fierce Day Lawson Limited 2004 RAJ 227 held that no latest patent appeal will lie against an order which is not appealable under section 50 of the Arbitration and Conciliation Act 1996. These orders are only appealable before the Supreme Court by way of special leave under Article 136 of the Constitution of India. Now, let us study the provisions related to foreign award under the Geneva Convention. Sections 53 to 60 of the Arbitration and Conciliation Act 1996 contain provisions relating to foreign awards passed under the Geneva Convention. According to the section 53 of the Act, foreign award under Geneva Convention means an arbitral award on differences relating to matters considered as commercial under the law in force in India, made after 28th day of July 1924. In pursuance of an agreement for arbitration to which Geneva Protocol applies, and between persons who are subject to the jurisdiction of country which is party to the Geneva Convention and declared in official gazette by the central government as a party to the convention, considering the reciprocal provisions, and in one of such territories declared in official gazette by the central government as a party to the convention, considering the reciprocal provisions. And an award shall not be deemed to be final if any proceedings for the purpose of contesting the validity of the award are pending in any country in which it was made. Application for enforcement. Section 56 provides that at the time of making an application for enforcement of foreign award, the applicant party shall produce before the court, firstly, original award or its duly authenticated copy; secondly, evidence proving that the award has become final; and thirdly, evidence to prove that the award has been made in pursuance of a submission to arbitration which is valid under the applicable law, made by the arbitral tribunal provided for in the submission to arbitration, or constituted in the manner agreed upon by the parties, and in conformity with the law governing the arbitration procedure. As per the Amendment Act of 2015, the application for enforcement of foreign award will now only lie to the High Court. Conditions for enforcement of foreign award. The conditions for enforcement of foreign awards under Geneva Convention are provided under section 57 of the Arbitration and Conciliation Act 1996. The award has been made in pursuance of a submission to arbitration which is valid under the law applicable to it. The subject matter of the award is capable of settlement by arbitration under the law of India. The award has been made by the arbitral tribunal provided for in the submission to arbitration, or constituted in the manner agreed upon by the parties and in conformity with the law governing the arbitration procedure. The award has become final in the country in which it has been made. The award would not be considered as final if it is open to opposition or appeal, or if it is proved that any proceedings for the purpose of contesting the validity of the award are pending. The enforcement of the award is not contrary to the public policy or the law of India. As discussed earlier, the Amendment Act of 2015 has restricted the ambit of violation of public policy for international commercial arbitration to only include those awards that are affected by fraud or corruption, or in contravention with the fundamental policy of India, or in conflict with the notions of morality or justice. However, the section 57(2) lays down that even if the aforesaid conditions are fulfilled, enforcement of the award shall be refused if the court is satisfied that the award has been annulled in the country in which it was made. The party was not given notice of the arbitration proceedings in sufficient time to enable him to present his case, or the party was under legal incapacity and was not properly represented. The award does not deal with the differences contemplated by or falling within the terms of submission to arbitration, or that it contains decisions on matters beyond the scope of arbitration, provided that if the award has not considered all the differences submitted to the arbitral tribunal, the court may postpone or grant the enforcement subject to some guarantee. Further, if the party against whom the award has been made proves that under the law governing the arbitration procedure, there is any other ground entitling him to contest the validity of the award, the court may either refuse enforcement of the award or adjourn the matter, giving reasonable time to have the award annulled by the competent tribunal. Enforcement and appeal. Section 58 provides that where the court is satisfied that the foreign award is enforceable, the award shall be deemed to be a decree of the court and entitled to be executed as a decree of the court. Under section 59 of the Act, an appeal can be filed by a party against those orders passed under section 54 and section 57 of the Act. However, no second appeal can be filed against the order passed under this section. These orders are only appealable before the Supreme Court by way of special leave under Article 136 of the Constitution of India. Dear viewers, from this lesson we have understood that the enforcement of an award under the Geneva Convention is cumbersome and difficult compared to the New York Convention. And in the present scenario, the New York Convention is very successful and the instrument for the enforcement of arbitral awards in international commercial arbitration. Hope you enjoyed this lesson. See you in the next lesson. Thank you.